We really appreciate.
Okay, so good morning, Damien. Welcome back to Senate Economic
long time.
Development and UI. It's amazing
Yeah.
how long it's been. Why don't you, I think it'd probably be best if you pull it up on the screen. I
All right.
understand there are not a lot of changes, but the ones that changes there are very large. So we'll walk through those and understand them. I think we've read about them and heard about them, but we also want to look at the sort of the nuances. We were speaking with Commerce Committee people last night, and they mentioned there's different reporting requirements, and so we need to know those as well. And if you can
Sure.
refresh our memory on the chargeability stuff and the offer and reoffer. I assume they haven't changed, but if you can just refresh what we did, that would be helpful.
Yeah, I'd be happy to. So it'll be a little bit complicated this morning because we have three different committees that have made amendments.
Oh, okay.
And those are, of course, not in, because it hasn't gone to the floor yet, they're not in a consolidated bill. So I'll start with the House Commerce Committee amendment. The first new section here, which you should see on your screens now, is section 5 to S62. It adds an intent section. What I did here is essentially just summarize what's in the bill. So I won't go through that. It speaks for itself.
Okay.
Section 6 is the experience rating relief for calendar year 2020. The only change that the House made on this is they made two changes. The first was to change the Senate had the period of March 15th to December 31st. And the House changed it to calendar year 2020 because that was at the request of the department for purposes of administrative ease. And then the other piece that the House did is they eliminated subdivision 3C, which related to the extension beyond 8 weeks by the commissioner, since the commissioner had explained that he was planning to extend everyone to the full length of time permitted, and then implement the Senate provision, which is the provides that
before you go on there, on doing all of calendar year 2020, does that mean that employers who prior to the pandemic laid folks off and there was no dispute as to their chargeability are going to be relieved of chargeability?
So the language in here still provides that if the commissioner determines that the separation was for a non-COVID related reason, or it no longer exists and the employer failed to rehire or offer to rehire the employee without good cause, that the employer is not relieved of the charges. So I think that with that in mind, you do have some protection against that. I think what this does mean, though, is that if there are if there are layoffs where it may be a close call as to whether it was caused by COVID, that those may slide under the radar. But that's very similar to what it was in the Senate. As far as the period goes, again, if the commissioner is aware that it was not a COVID-related reason, the commissioner is supposed to not relieve the employer of charges for those benefits.
Well, I'm a little we wanted to give a lot of flexibility from the COVID period on, from mid-March on, but it sounds like this gives the commissioner discretion in a broad sense to uh, even when, my understanding of the process, I could be wrong, but is that, when there's a layoff and a separation, there is at that particular time information gathered. And um, maybe you could find out for us, Damien, through a call to the department, if they, in January, there was a layoff and the employer is not contesting that they should be chargeable, and uh, is that enough under this statute? As I recall, we had some, uh, I don't want to say convoluted, but a little complicated language that said if the commissioner was aware of such a circumstances, which he should be aware from his own file, he should pursue chargeability.
Right.
So, uh,
Right, so that is here on page 10, line 7. If the commissioner has cause to believe
Excuse
that
me,
an
Dave,
employer may not be entitled to relief.
Dave,
Yeah.
you
is
just
that
looking at-
2020 that we're talking about still?
This is 2020 that we're talking about, yes.
So why do they need this language to go to the full calendar year?
So my understanding from the testimony that I heard was that they believe this would make it easier to administer from an internal standpoint. But I can't speak for the department, but that was my understanding from the testimony that I heard.
Okay, Senator Clarkson, do you have a question?
No, I just wanted to give you an update on Becca. She'll be joining us ASAP.
Okay, thank you.
And you're right. I mean, it's to not start it as of March 15th or something is just puzzling, given that we're now folding in people who may well should be charged for what they, for laying people off. So anyway.
Right, and
we are-
the worst fear is that everybody gets, the entire year gets relieved of chargeability, and then some employers who had no layoffs are in comparison to those that have layoffs,
Right.
are going to be adversely impacted.
Right.
Okay, let's keep going.
Okay. Just making a quick note here. Okay. The next section here is the 2021 charge relief. There are no changes from the Senate in this section. As you may remember, what the Senate did in this section is they moved the requirement that an employer rehire or offer to rehire or have good cause for not rehiring or offering to rehire an individual in order to get charge relief. And that includes voluntary separations as well as employer layoffs that are COVID related. So that language is the same in here. I misspoke. There is actually one House change, and that is that they moved the April 15th deadline to submit a report summarizing the procedures and application form and to begin public outreach to June 15th, just because of how late we are in the year. Originally, that had been moved to May 15th, and then that date is obviously passed as well. So that's the only change there.
Okay.
Section 8, I'm still thinking in terms of S10 here.
Okay.
Section 8 of S62 extends the sunset for the 2020 COVID-related provisions around experience rating relief in Act 91. And that's the same as the Senate. So the first day of the calendar quarter following the quarter in which the state of emergency is lifted, or if the state of emergency is lifted in the final 30 days of the calendar quarter, thus the first day of the second calendar quarter following.
Okay.
Section 9 is the housekeeping provision related to the federal waiver of the waiting period regarding what happens if you go on into an extended benefits period and then the official unemployment rate drops. So you go out of the extended benefits period. the federal government has allowed us to waive the calendar quarter waiting period to go back onto extended benefits through the end of this year. And this is just language that allows that to happen. At this point, we are not on extended benefits, but if we have a spike and then a drop and then another spike in the official unemployment rate as the year goes on, this would allow us to provide additional benefits to individuals.
No change from the Senate version, right?
No change from the Senate version at all. The next section is new, section 10, and this is on page 14 of S62 as passed House Commerce. And this is the maximum weekly benefit language here. What we've done here, you see a lot of strike through from lines 11 through 21. That is taking out language from the grand bargain, which was implemented around a freeze on the max weekly benefit while we were in a loan status with the federal government. And because we're not in that status now, what we're saying is it shall annually be adjusted on the first day of the first calendar week in July to an amount equal to 57% of the state annual average weekly wage as determined by subsection G. Despite all of the strike through, this is not a substantive change in the law. It just brings us back to what is essentially happening each year and hopefully clarifies the section a little bit. The change that the House made is here on page 15, line 8. They added this new subdivision A2B that says the maximum weekly benefit amount shall not decrease. The reason that that is necessary is because the pandemic, with the way it impacted low wage jobs, the state average weekly wage had a spike last year. And what may happen as low wage jobs come back online is that you could see the state average weekly wage actually drop. And the old language said it shall be changed by the percentage change in the state average weekly wage. So this is language saying you can't actually decrease it. So if we do see a decrease, it'll stay flat. And then when it starts to increase again, it'll go to 57%.
So there's no, if we need to avail ourselves of this new section, there's no impact on what future years will look like. Okay.
Nope.
Okay.
So what will happen is if the state average weekly wage drops, the maximum weekly benefit for UI will freeze and it'll stay where it was the year before. And then when the state average weekly wage starts climbing again, as soon as it's climbed to a point where 57% of the state average weekly wage would be higher than the former max weekly benefit, you'll see that max weekly benefit just trend back up.
Okay, good.
Can I just ask, I'm grateful for this change. In the last 10 to 20 years, has the weekly benefit amount decreased? Okay, so it's an important change, but it's not huge in terms of impact. I just want to know.
No, it's unlikely to have an impact in most years. It may have an impact in the next couple of years when we see the wage fluctuations from the pandemic work out. So that's the only reason it was added. Otherwise, I think 5 years ago, we would have said this probably was completely unnecessary.
But this section is a good reminder, quite frankly, that it's 50% of the state annual average weekly wage. This is not 50% of 57% of your wage that you had before you left. So when people, we've heard some pretty insidious comments about, why people aren't going back to work, that they're earning so much on unemployment. This is just a great reminder and underscore of they're not earning 50% of 57% of what they earned. It's 57% of the state average annual weekly wage, which for many people is a lot lower than what they were earning.
Yeah, so just to clarify that, about 1 in 4 UI claimants, and it fluctuates from claim week to claim week, about 1 in 4 UI claimants receives the max weekly benefit because their pre-unemployment wages were above the point, they were above 57% of the state average weekly wage. And so, or they were above the state average weekly wage, excuse me. And so they get capped at 57% of the state average weekly wage. And then the other roughly 3/4, and some weeks it's less, some weeks it's more, will be receiving 57% of what they earned before they went on unemployment because their wages were lower.
Right.
And of course, this can vary in recessions. The recession we had about 12 years ago affected higher wage earners more than low wage earners. And this pandemic-induced recession is obviously the other way around, where lower wage earners have been disproportionately impacted.
So, and just to add to Senator Clarkson's point, is that for workers' compensation, you get 2/3 wage replaces 66% up to a cap. And last year, when we were dealing with paid family leave, many of the advocates wanted 90% or 100%, which is kind of strange when you compare it to people who are unemployed, who are injured on the job, in terms of, equitable treatment. So I think this is a laggard in some ways in terms of what the wage replacement is. So
I think it definitely is. And next year, I'd really love to dig into our benefits. And I know we have a report coming back in here, but I'd really like us to look at our entire benefits packages around workers' comp and UI and see how they compare to the rest of the country, because I understand we're considerably lower than other states.
well, I'm not sure that's true. I think we're probably
really?
we're
Okay.
probably in the top half or maybe higher, but we're not super generous either. So can we go on?
It really depends on where we stack up, depends on how you look at it, whether it's the max benefit, the average benefit, or what our wage replacement percentage is. And some of that's affected by the state's wages. And then there are other factors to keep in mind too, like the waiting week that some states have that we don't have.
Right.
And things like that all impact it.
A lot of moving parts for
There
sure.
are a lot of moving parts, but that is in section 14A, which will be the very last thing I get to today.
But just last point on this, remember that we in Vermont underpay across the board in all sectors about 20%.
Okay.
But we're already at an earning disadvantage in Vermont.
Good point. Okay, section 11.
So section 11, this, so the strike through in subsections B and C, if you look closely at the struck through language, you'll see that both of them start with the lead in for the benefit years beginning prior to January 3rd, 1988. This is part of my effort to get rid of language that hasn't applied since before the Seoul Olympics, for those of you who remember. And so we're just repealing this language since it hasn't applied in over 30 years. And that allows us to take out the lead-in language to subsections D and E, which is for benefit years beginning on January 3rd, 1988, and subsequent thereto. The substantive change here is found at the bottom of page 16 in subdivision E2, and this provides that individuals will receive a supplemental benefit of $25 per week in addition to the amount their normal weekly benefit. So, and this is notwithstanding the maximum weekly benefit. So even if you're earning what is currently $531 a week, you would receive $25 on top of that. Two important things to note with this. One, it takes effect 30 days after the federal FPUC $300 supplement is terminated. The reason for that is that our mainframe system, according to the department's testimony, can currently implement only one supplemental benefit at a time. And then the 30 days gives them enough lead time to reprogram it and test it to make sure it's not going to crash the system before they roll it out. But this will go to everyone, not just individuals with dependents. So it's replaced the dependent focused benefit that the Senate passed with a $25 weekly benefit. The second important thing is that the repeal date is a contingent date based on when $100 million in benefits have been paid out. The projection with no recession is that that would occur sometime in the mid-2030s. Of course, if we have a recession, we would expect it to occur sooner because a lot more benefits will go out during a recession. But it's hard to project exactly when.
So just one question on this, Damien, is pretty clear. People who are on PUA right now or not are benefits that are not part of the trust fund, they wouldn't get this $25, and those benefits, are they targeted to cease at the same time as the $300?
As of right now, the federal benefits are all set to expire on September 6th. So this would take effect after all of the federal COVID-related programs have expired. So unless there's an extension that extends PUA beyond the FPUC supplement, we would expect that this would just apply to regular UI benefits for the state. So if PUA is extended, the PUA law provides that individuals would receive wage replacement at the same rate as provided under state law. I'm not sure how it would relate, though, to a state supplemental benefit. And so that would be, I think that's a little bit of an open question, but we're not expecting it to apply to PUA benefits at this point because they're expected to expire before this would take effect.
What's the trigger? I guess it's later on, but in the effective date, what's the language that triggers this $25? Is it the elimination of all supplemental federal programs, or could you have one supplemental program be terminated and another go on? For instance, the $300 terminates on on September 6th, but PUA goes on. Would the PUA people under the language here get the extra $25?
So this is, the trigger in this is 30 days after the termination of the federal pandemic unemployment compensation supplement. So it doesn't,
just the $300.
Just the $300. So if PUA is extended, then we would have to, at that point, consult with the probably federal DOL just to see how this would apply. Because the language there, and I'm going off of memory here, but the language addresses the wage replacement rate for the state and doesn't speak to supplemental benefits. So I'm not sure if this would be considered as part of the rate for PUA.
Okay, maybe you could dig a little deeper into that, whether, I don't know that we would be allowed to make a further change to sort of decouple what we pay PUA versus everybody else, but we may want to, I think this so-called grand bargain too was, I think, not premised on paying out additional $25 to PUA people. But anyhow, let's move on.
And I
Go ahead.
I was just wondering if this came up in the House, Damien. I mean, early on in the House's consideration, there was a lot of concern about people who receive other benefits and falling off the benefits cliff. Did that come up in this context in terms of if somebody at some point when the system is set up could elect not to receive the supplemental benefit? I know it says shall, but maybe there's a case for people who would automatically get it, but then want to be able to go back and say, I don't want this because it might actually hurt me.
So the and I'm gonna just speak on what I know from the public testimony. I haven't been involved in a lot of the conversations behind the scenes, and of course, to the extent that I was, I can't necessarily disclose that. So there was concern expressed in the House about the benefits cliff. There was also concern that if there wasn't some sort of additional benefit provided, that the bill wouldn't go through. So to that extent, with this added in here, there was not discussion with this particular supplemental benefit related to the benefits cliff. And so, as far as the benefits cliff goes, I really don't know enough about where all of that falls, because that's been a moving target too, as we've made changes to other laws.
Yeah.
And so the last time I looked at that was in relation to the minimum wage a couple of years ago. And I know there have been subsequent changes, and I don't know the extent to which that's a factor here. But I know that the discussion around this was mostly trying to, there was a lot of discussion about whether you support or don't support the supplemental benefit. This is something that's necessary to make sure that this is something that can help the legislature get to yes
Right.
by giving something to each group
I
in terms of
appreciate
what
that,
they're
Damon.
asking for.
I don't want to make you
So-
go any further. And because I've
Yeah.
always felt like, well, it's already a percentage of your previous wage. So it felt really unlikely that it would trigger a benefit cliff if that's not where you were necessarily before, and it's a temporary benefit. I just didn't know if that entered into the conversation. So
Yeah, and I just don't know enough about the calculations for those sorts of benefits to know how UI factors into that and how close it would bring you. That really would be a better question for folks who study sort of the various benefit curves and also have a better understanding of what benefits you're likely to be eligible for
Right.
while you're receiving UI, and the extent to which people on UI actually seek out those benefits.
Exactly.
And I just don't know the answers to any of those questions, unfortunately.
Okay, let's move on.
Okay. So section 12 is just a repeal of that. Like I said before, it's contingent on $100 million in supplemental benefits being paid out. Section 13 is a brand new section. This amends 21 VSA 1309, which are the reports, the annual reports on the solvency of the trust fund. And it adds to that report a requirement that the Department of Labor include an accounting of the amount of the supplemental benefits paid out during the prior year. And then it also, in subsection B, adds a requirement that the commissioner report promptly to the governor and then the chair of this committee, the finance committee, and House Commerce and House Ways and Means if the balance of the trust fund drops below $180 million. And this replaces the $90 million triggers in the Senate bill. So it's a higher level, but it's just a report to the legislature at that point. It doesn't trigger benefits being shut off or a revision in tax rates.
Have we, in the testimony you heard in the House, this whole thing with these cyber fraud things that are going on, I know that, I think in my case, I was told that 3 weeks of benefits were paid out to some person. And that they're talking about millions overall being fraudulently collected. that we're probably never going to get back. Has anybody talked about where that's dropping the existing balance of the trust fund at this point?
I don't recall hearing that testimony specifically. It may have occurred when I wasn't present. But I've seen estimates of that, but I don't recall specific testimony about that. I'm not sure that we have a clear idea of that yet. Matt Barowitz or the commissioner would probably have a better sense, or Cameron would.
I'm looking at this language in subsection B, and I wouldn't be surprised by the time this law becomes effective that we're below that number. What happens then?
It's just a report to the legislature, and the legislature can decide whether to act or not on that.
But I mean, would there, okay. I mean, I guess it could be a one-sentence letter, but I'm wondering whether it would be required if at the time of effective date, where we're not dropping below 180 million, we already are below 180 million. So, okay, let's move on. This is a minor point.
Yeah, and I don't know the current balance of the trust fund, so
I think the last I saw, and this is a couple of months ago, I think it was like 210 million or
Yeah, it
something.
was 214, I think. Yeah.
Right, and it's worth mentioning that so this passed out of the Senate in late March.
Right.
And then in the beginning of April is when the first round of UI contributions comes in.
Yeah, this is the sort of the high period to start getting collections in.
Right. So the balance may have actually bounced up since then.
Got it. Okay.
So section 14, I'm going to skip over this because we're going to get to it with the House Appropriations draft. And it replaces this section.
Okay.
Sections 15 and 16 are the extensions of, or the changes in the reporting dates for the joint report from the AG and the Commissioner of Labor on their dual enforcement of employee misclassification, and also the report from the Employee Misclassification Task Force, which is supposed to be an interim look at that with recommendations for changes.
That's unchanged from the Senate, right?
It looks possible that House Appropriations may move that date a little bit later to coincide with the other report dates, but they haven't finalized their language yet. But they're looking at a later date with the idea that instead of having it be an individual bill, any bill would be a committee bill, because we still have the committee introduction can occur at the beginning of the session, just to give more time for the other reports.
But the major purpose of our actions on this, which this is the same as our actions, right?
This is the same as your actions.
Our major thing was not so much, I think, trying to speed it up or get ahead of bill introduction. It was to have it be on track with what we were asking for on the same dates as what we were asking for on unemployment report, right?
Right, and the discussion in House Appropriations on Friday was about moving out the report deadlines because of the challenges identified in reporting on everything that's being asked in the new reports, right, by November 15th. So giving an extra month for that, and then allowing the committees of jurisdiction to do a committee bill,
right,
around that. So this would just move to align with that.
They can both elements would both track the same date, which was one of
right.
them. Okay.
They'll all continue tracking the same date.
Okay.
So the effective dates here, this is even more confusing than it would be normally, because we have all of the effective dates that David is dealing with. The important thing is the extension of the sunset is retroactive to March 31st. The supplemental weekly benefit is effective 30 days after the FPUC program ends. And then the repeal of the supplemental weekly benefit takes effect with the benefits payments beginning in the next week after we hit $100 million. And then everything else in the UI portion is effective on passage.
So go ahead. I'm sorry. Go ahead. Keep going.
I was going to say that's the House Commerce piece. There's still Ways and Means, which is the tax piece, and then Appropriations, which is the reports.
Are you prepared to go through those for us now?
Sure. Let me. Oh, whoops! I almost left the meeting by accident there. Clicked the wrong button.
May I ask a question, Damien?
Senator
Yes.
Brock.
It's obviously I'm sorry I came in late to this, and it may already have been covered, but I see that what we've done here is we've taken a lot of pieces from S10 and put it into this new S62. My question is, what happened to the provisions we put in regarding fraud in S10?
Those are in the report that is being worked on by House Appropriations. So I'm going to get to that and on the last piece. That's the last piece I'm going to get to, because it's been split up into two pieces, one which is a legislative study, one which is a consultant study.
Okay. And then the next question that I have, and it may not be relevant to going through this bill on a line-by-line basis, but it relates to fraud that maybe you could perhaps address separately or offline. And that is, we have this massive fraud that is occurring right now. Are we satisfied that we have criminal penalties in place to deal with this kind of systemic fraud?
So one of the things, just like in the Senate bill, that's requested in the consultant study is looking at making sure that figuring out when it's appropriate to refer for criminal prosecution and consulting with the AG and the state's attorneys about that process. Right now, I think there is criminal fraud provisions in place for things like false pretenses, as well as for identity theft. So theoretically, some of these frauds can be prosecuted. But I think, as you'll remember, both the AG's office and the state's attorneys said they needed additional resources to go after this. And so that's one thing that the consultant report is looking at. It basically takes the Senate language, and instead of requiring the department to do the report, requires a consultant to do it. And that really was around the House's concern about getting an independent entity to evaluate it, so that you have just the independence in the sort of results, so that if you get a result that says the state is doing everything that it can, you're not concerned that it's glossing over a shortcoming or something like that. And so that was something that was important to the House, but otherwise they've kept the Senate's focus in that report that was added in your amendment.
Well, I guess the concern that I have, and again, I don't want to detract from what we're doing and going through this bill because I know time is short, but in doing this bill or any other bill that relates to this, I think it's imperative that we act to ensure that there are, in fact, criminal penalties, because we're under attack by outside entities, potentially affecting thousands of Vermonters and stealing millions of dollars, up to millions of dollars. And the notion that we're going to agonize about doing a study as to whether or not it's a crime is just insane.
Right.
That's
I would just, my one response to that would be, my understanding from the House testimony is that the department has taken additional steps since the bill moved out of the Senate to address that, and is continuing to take steps. One of the most significant they cited was taking down the website application process. And because they were at a point where they were flagging 90% of the applications on the website, or better than 90%, as fraudulent. And they saw a significant drop in claims, period, when they went to the phone process where you have to talk to a human being and go through the application process that way.
So I think that Senator Brock raises a good point, and I think his point is the world has turned over several times since the bill left the Senate, and we've got a new problem on our hands, and we should determine whether the tools that the AG and others have can address that now, and if it can't, it shouldn't wait for a study. On the same hand, we have a bill here that needs to move forward, but there are other vehicles to add language to, and it could be this one, depends how it plays out. But if we're vulnerable or naked here in terms of these things right now, I agree with Senator Brock. We don't want to wait till next consultant's report to have the tools to do something, and we could make sure that we find a home for additional language. So the first thing to do is we're going to have to find out, I assume the AG and the department are talking to each other. Maybe that's a wrong assumption. And that they're figuring out what they're doing about this. I agree that what they did on the webpage is a good thing, but I think we want to be bringing some criminal charges against people if we know who they are, so.
Right, and I'd have to defer to the department on that. I just don't know what their process is right now.
Okay, so you were going to move on to Ways and Means, I think?
I am, yes. So let me share that screen with you. Okay, so this is the Ways and Means Amendment here. This replaces the tax relief provisions in the Senate bill. The changes on the first page are just technical changes, adding hyphens and replacing which with that. The important change here is on page 2, subsection B. It says, notwithstanding any provision of subdivision A to the contrary, when computing the tax rate scheduled to become effective on July 1, 2021, and on each subsequent July 1, the commissioner shall calculate the highest benefit cost rate without consideration of the benefit payments made in calendar year 2020. So boiling that down, what it does is it takes the benefits paid out in 2020 out of the formula, which means that the formula is not going to try to drive the balance of the trust fund up to $1 billion. Instead, it ends up driving the balance of the trust fund to around 600 million. What this means is instead of going straight to Schedule 5, and I'm going from memory here, Matt Barowitz provided a chart that tracks this, but I believe it goes Schedule 3, Schedule 4, Schedule 3, Schedule 3, Schedule 2, and down. So it brings us on a less drastic track in the long run, but the trade-off is that employers don't get Schedule 1 next year, and there is no taxable wage base freeze. So that stuff moves normally. The bottom line is over the long term, there's about 400 million less in contributions paid before you add in the supplemental benefit, which of course will drive down the balance of the trust fund. So you'll end up having to pay contributions to over the 10 to 15 years that's in place, employers will end up paying additional contributions to refill that amount.
You mentioned the taxable wage base. I think our bill, if I recall, froze the taxable wage base for 1 year, and then it had go back to existing law as if that freeze hadn't taken place. Did the House change that?
Yeah, they took that out altogether, and this is their change on taxes here, is just to take 2020 out of the calculation.
Okay.
So there's no wage base freeze, there is no tax rate freeze.
Okay.
That all functions normally, except the formula isn't counting last year's UI benefits paid.
Okay. Does anybody have any questions on this? This formula, if you get into the weeds with it, is very complicated, but basically this is a COVID relief bill in terms of an aberration of how it affected contributions. And this is one way to skin the cat to lessen the tax spike on employers.
I
Senator,
just-
Senator Rahman, looks like you have a question. No?
Yeah, well, you know, I knew this was coming. I knew the House did this. I wonder if we know if other states are doing this as well. I mean, I get it's an anomaly, but it was a huge year where we paid out unemployment across the board in the country. So I'm just curious I can go ask some national groups. Are other states doing this? Are they averaging the exclusion? They talk about it.
The answer is I don't know what other states are doing across the board. I know some other states have used CARES Act or ARPA funds to pay down the amount of UI benefits they've paid out. Other states may be adjusting their tax rate. So this approach here was one within the existing formula. So it doesn't change the formula that was arrived at in the grand bargain. And it just takes out the aberration of last year, where it was an extremely unprecedentedly high level of benefits in 1 year. And you still are going to end up with, the reason why it goes to Schedule 4 in the second year is because this year is still a very high level of benefits. And so that's going to keep driving the balance or the rate up in the short run. And then right now we're pulling in 2011, which was not in the heart of the 2008 recession, but still in the recovery. And so you still end up at Schedule 3. So, but yeah, I think the legislative study that's being proposed in the next amendment I'm going to show you is going to take a deeper look at the trust fund and the solvency of it. And that's going to probably give us an opportunity after most states have adjourned their legislative sessions to see what they've done. Did they use ARPA funding or CARES Act funding? Did they change their tax formula? Did they change their other benefit funding ratios, that sort of thing? Because there are a couple formulas that are at play here, and some of them are fundamental to our UI system, but they're also not the only model. There are other states that have different models that may have dealt with this pandemic better or worse. So that's something that legislative study committee may have some chance to look at this summer.
Damien, Michael, may I ask a question?
Senator Clarkson.
Thanks. Damien, was there any discussion of taking the first quarter of 2021 out of consideration also?
I don't remember the exact specifics. I do know from my memory, there was discussion of 2021 and how you might want to factor that. And I think they just settled on, they ultimately settled on calendar year 2020. But certainly they're conscious of the fact that at least the first quarter or first half of 2021, we're continuing to see very high benefit payments. But I think I'm trying to be careful here not to put words in the House's mouth, but I think the impact of taking 2020 out, bringing it back down to closer to what we were at historically, following the Great Recession, seemed like a reasonable starting point, especially with a legislative study coming to look at whether that's an appropriate place to leave the balance in the future, and whether there needs to be additional tweaks to the funding mechanism. So.
Okay, could we move on to appropes?
Yep. Okay, let me make sure. Okay, great. So this is the draft of the appropriations amendment. I have to be clear, this has not been voted out by Appropriations. They're going to be looking at additional amendments today. So the first thing is this section 14 replaces the Department of Labor.
Can I just understand better? This language is now separate from S62, but appropriations is still voting on it separately than the budget.
So no, this is an amendment to the Committee on Commerce's report on S62.
Okay.
So Commerce is being amended by 1, Ways and Means to add in the tax relief, and then 2, Appropriations. So House Commerce had an enormous JFO consultant study on, it basically consolidated all the studies from the Senate bill and then added a few things. And the estimate from Dan Smith was that would cost JFO somewhere in the ballpark of $500,000 and likely be something that was beyond JFO's resources to supervise this summer, because they have a number of other studies that they're being asked to hire consultants to do. So first things first on this, on line 13, Joint Fiscal Office is likely coming out of this, although that hasn't been resolved yet. So the consultant study may be run through for example, the state auditor's office or something like that, but that's still an open question. The committee hasn't had a chance to determine that, but Joint Fiscal Office has concerns about its resources to actually oversee this. The second thing that Appropriations is doing is they're breaking the study into 2 pieces. One part is a legislative study focused more around policy issues, and one part is a consultant study focused more on procedural and departmental function issues, looking at that. So it's asking the consultant to evaluate the Vermont's UI system in comparison to other states, considering the needs of claimants, employees, and employers, as well as the modernization of the department's IT systems in the next several years. And then to look at existing practices and procedures for detecting and preventing unemployment insurance fraud, instances in which it may be appropriate to refer fraud for criminal prosecution, including a reasonable minimum threshold, potential measures to eliminate or minimize claims processing delays that result from fraud prevention measures, and the existing practices and procedures for preventing, reducing, and collecting overpayments of UI benefits. So these are the things that were the focus of Senator Brock's amendment to the Senate version of S10. And then in performing the evaluation, the consultant is directed to specifically identify best practices and high-performing aspects of other states' UI systems, the shortcomings, challenges, and opportunities for improvement in our own system, and then potential changes at an administrative level at the department, whether that's staffing, resources, IT improvements, additional training, better communications, et cetera, that are necessary to identify the identified shortcomings, potential statutory changes that are necessary to identify those. So for example, is there something in our statute that prevents the department from doing something? And then the anticipated cost of both implementing and any ongoing costs associated with those changes. So maybe there is a best practice the department could implement, but it's cost prohibitive. And maybe there's a more cost-effective solution that other states have implemented that isn't the platinum standard, but provides gold standard performance. And then they're required to consult with Department of Labor, the Attorney General, Department of State's Attorneys and Sheriffs, representatives of employers, employees, and claimants, and the Appropriations Committee also asked that Agency of Digital Services and Department of Human Resources be included in that consult.
I was going to say, where is the Agency of Digital Services?
Yep.
I'm wondering, is this in addition to language that exists elsewhere in the budget on phase 1 of the Department of Labor IT plan?
Yeah, so this is really looking more at how do we address these identified problems around fraud, claims processing, and collecting overpayments of benefits.
Yeah.
Um,
I
keeping
don't
that
see
in
the
mind.
term cybersecurity in here, which is interesting to me.
One quick observation, I see the entity to hire to do this to be either an economist or an independent consulting industry.
The committee has asked that the economist language be taken out. This is the draft
Okay,
they looked at Friday.
Good.
So thank you for mentioning that. One of the early draft here had asked for an economist because it included so many things related to the solvency of the trust fund. But because that's been moved to the legislative study, that obviously it makes more sense to have a consultant who's got a lot of experience in UI program operations, who can speak to things like how to streamline the IT system and improve training and implement better communications and implement better fraud prevention tools, whether those are the tools that the National Association provides or other tools that other states have implemented on their own.
Good.
So this requires the department to cooperate with the consultant and to the maximum extent permitted by law, provide them with prompt access to all information requested. It's basically acknowledging that federal privacy laws prevent certain information from being disclosed that might reveal, for example, details of an individual claim. But on the other hand, you can reveal some aggregated information that can give the consultant the information they need. As I mentioned before, the committee is looking at moving the report date out from November 15th. So it'll probably be December or January 15th. And we'll know this afternoon on that. And then just like in the Senate bill, the consultant has to omit any information regarding fraud detection techniques, procedures, and guidelines that could allow an individual to circumvent the law. The definitions are exactly the same as what was in the Senate bill. So that is focusing on the procedures. And then section 14A is a legislative study committee that focuses on the other aspects of the studies. Before I go to that, are there any other questions on the consultant study?
Well,
Yes, I have a comment, more than a question. If we're going to try and get to a report here that we can concur with, I'm concerned that it's not clear that all the elements of fraud in that section do not deal with the classic case of employer fraud, of misclassification, where they 1099 employees that should be listed as W-2 folks. So I'll probably get a note off to the Appropriations Committee. Could they please just make it clear that fraud in all those cases is not just limited to beneficiary fraud?
Well, the reason why the Senate limited it to beneficiary fraud is because we have two other studies on employee misclassification that are required under last year's law. So that was a Senate choice to limit it to beneficiary fraud.
So this is not going to subsume those other studies at all?
No, those studies continue. The only thing that the Appropriations Committee is talking about is changing the due date for those studies, so it coincides with this one.
Well, I know about the AG report on misclassification. What was and there's a task force. Is there any other study that we had in the Senate version that's being substituted here?
No, so we took those two studies and kept them because the misclassification task force, it's an interim believe it's an interim report, but it's
Yeah.
basically to identify additional statutory changes
Okay,
to improve the enforcement of the laws against employee misclassification.
okay. But I thought, didn't we have, maybe it was when we were just doing a 1-year fix here. I thought we had a big study to come back to us on the health of the trust fund and what needs to be done. That seems to have disappeared, correct? From the Senate?
That's in section 14A.
Oh, we're getting to that? Okay.
Yep, we're getting to that.
Okay, sorry.
No,
Let's get
that's
to
okay.
14. Okay.
Any other questions before I move on?
I have, I mean, I feel like one of the biggest issues this year was identity theft, and one of the sort of unspoken issues with things moving into the digital space is cybersecurity. And I maybe like the chair, I don't know how much room there is to ask for some consideration of those things while the House is looking into this. It just feels like a huge omission to me. I mean, that's what happened. People lost their identities in this process, and we didn't have a good system in place to help them.
So, I mean, I think I can't speak for the House members, but you could certainly reach out to the House members who are have been kind of the point people for their committees on this. So that's Representatives Tolino and Feltus from the Appropriations Committee, Representative Kornheiser from Ways and Means, and then Representatives Kimball, Jerome, and Marcotte from House Commerce.
Okay.
But Damien, Senator Robb's concern is not within that language at all in section 14?
So it's covered by the umbrella term, which is the intentional misrepresentation or knowing non-disclosure of a material fact by a claimant or any other entity for purposes of obtaining unemployment insurance benefits. We specifically added the or any other entity language in the Senate to cover organized crime and the various sort of organized internet efforts to, whether it's through AI or some other organized crime effort, to submit fraudulent UI applications based on identity theft or some other means. So that was specifically added in the Senate version. But if you're interested in, for example, in number 1 on page 2 here, the department's existing practices and procedures for detecting and preventing unemployment insurance fraud, you could say something, to the extent of including related cybersecurity issues, or including, issues related to cybersecurity and identity theft or something like that. If you really wanted to just call that out and flag it as something that's very important. And I don't think it really, it definitely doesn't hurt the study language. And if anything, just it flags it. I think that the umbrella is broad enough as it's currently written to capture that, but it's not something that's going to dramatically change the meaning or take something away from the study. So that's something you could reach out to the House on and see if they'd be willing to include that language.
Okay, let's move on to the legislative study, and then
Then
we'll take a little break, and then we'll go to David on remote relocated workers.
Great. So I'm going to just go straight to the membership of the committee and then to the specific issues. So the committee is composed of 4 members, a current member of House Commerce, current member of House Ways and Means, both appointed by the Speaker, and then a current member of this committee and a current member of Finance, both appointed by the Committee on Committees. So it's a 4-member study committee. The committee is tasked with studying the solvency of the UI trust fund and the amount necessary to ensure that it remains solvent and able to continue meeting the needs of claimants during a future economic recession and the House added and subsequent recovery. The adequacy and appropriateness of Vermont's unemployment insurance benefits, including whether they should be increased and whether the Vermont statutes related to benefits should be modified in any manner. So that gets to the question of whether the benefits are sufficient and whether there are any other modifications that should occur. Instances for which it may be appropriate to provide the Commissioner of Labor with authority to reduce or waive a period of disqualification. So these are penalty weeks related to UI fraud. And this is something that the House added, which was a topic of discussion last year. Instances when it may be appropriate to provide the Commissioner of Labor with authority to reduce or waive an individual's liability to repay overpaid UI benefits. So again, this is something that I think was discussed last year, and I can't remember if the House or the Senate added this. But it's along the same lines. When do you provide flexibility around an overpayment? And then the final piece is something the House added: potential statutory changes to mitigate the impact of benefit charges on reimbursable employers who paid wages to a claimant during their base period, but not cause the claimant to become unemployed. So this is an instance where an individual's left a reimbursable employer, which is likely a nonprofit, or, well, it's either a nonprofit or public sector, and then they get laid off from their next job. But because most of their wages in their base period are from that nonprofit or public sector employer, that employer ends up getting a very large bill, even though they had no role in that individual becoming unemployed. And this is an issue that before the pandemic, the department was hoping to work with the legislature on addressing. And so this is just asking them to come to, this is basically putting it in the legislative study so they can come to the study committee with proposals, and the study committee can start evaluating that.
Is this very different? Other than the structure, is the charge very different from what we sent over?
No, the rest of the language tracks the other, the consultant study. And then the assistance is the normal Ledge Council, JFO, Ledge Operations, and they're allowed to have 3 meetings.
Really? We think we're going to solve those in 3 meetings?
I think the understanding is that this is probably going to be something that's gets a lot of discussion next session, but that they're supposed to come back with an initial proposal after 3 meetings. So.
Okay.
I think that's a huge charge for and very restrictive on time.
Yeah.
Just saying.
So again, that would be something that you may want to reach out to your House counterparts and ask them to change.
So this is actively now in Appropes, and they've got to vote this out today because our time is so tight.
Right. So this is on the agenda in Appropriations, I believe, for 3:30 this afternoon, but I've had about a half a dozen emails come in while I've been talking to you, and I don't know if some of those have told me it's a different time. So, but it tentatively for late this afternoon.
Okay.
And whose area is UI? On that
Representative Tolino and Representative Feltus are the 2-point people for appropriations on this because of the overlap with UI and IT issues. And then Representative Kornheiser from Ways and Means, and then Kimball, Jerome, and Marcotte from Commerce have been taking the lead from those committees.
Right. No.
So
I thought you were asking Senator Clarkson, who's the staff person who's going to be working on this?
That would be me.
know who the staff person is who will be working with us. There's always a reason to want to be on a summer study committee with Damien, because I have always appreciated my work with Damien in the summer.
Yeah.
Okay, so let's take a break. Thank you very much, Damien. That was very helpful.
Great.
Can we take a break till 10:55? And we'll come back and we'll deal with the other parts of S62, as you recall, was the relocated remote worker. Essentially, I think what the House did is they got rid of the remote worker portion of the bill and added some CTE portions that had not appeared to date. So, but David will walk us through those changes, and we'll take it at 10:55.
And may I just ask, in the intervening time frame, we don't have any documents up for today, Amy. If we could post that 3.1 draft that Damien was working off of, and the Ways and Means draft, and I think Approps, obviously, they're in the process.
Yep.
So,
Yep. I can send you those drafts, Amy.
Yeah,
Oh,
Thank you. I'll have to consult Peggy as to how to get them onto your page. I'm not sure I have access to that, but I can certainly make sure it happens.
yeah,
Okay.
it would just be helpful for us to,
Sure.
as we weigh what we're going to do.
Sure.
Okay. Thank you very
I'm going
much.
to take you off live and we'll go back on at 10:55.